I wanted to touch on this real quick. In Alabama, this was amended in 2018. This is back to the Jamari Williams Bullying Prevention Act. This is a common issue, a common set of confusions that I run across with parents. So it's good for advocates to understand this because schools should understand it or do understand it. But I'm going to go ahead and throw this out there. And I do acknowledge and recognize any philosophical disagreements school administrators may have with me on this one. But this is another one of those state requirements that could potentially blemish a principal's good marks on ESSA submissions and all of those wondrous things that bullying is not something that you want inside your school. Now, how do you get around with not reporting bullying inside your school? You don't document it. If you don't document it, it doesn't exist, you see? Doesn't mean that bullying isn't happening. It doesn't mean that parents are not approaching you and discussing it with you. Doesn't even mean that you don't have your own personal notes in your office that nobody sees, addressing it. But what does the state law of Alabama say about it? It says that if you don't put it on the sheet, it didn't exist. You got to use their form. Got to use the form, got to use the form, got to use the form. And hold on, one more. That's right, you got to use the form. So at the very bottom, on a form authorized by the local board. On the form authorized by the local board. So every school is going to have, in fact, they're mandated to have it open and openly available. In fact, it says it needs to be somewhere in the office, close to the principal, to where if a parent comes in, the form can be handed to them and say, here's the bullying form. Our local recognized board bullying form. Or it's available on your website. But if you bury it 3 or 4 links in, then it's hard for a parent to find. And a parent believes that if they just go in and talk to the principal, and then when I talk to these parents, I end up finding that I said, well, did the principal mention the anti-bullying form that was approved by local board policy? No, I had no idea there was a form. They just said they would look into it with the quotes. If you don't put it on the form, it doesn't exist. If it doesn't exist, it's not tracked. If it's not tracked, you don't get a blemish on your mark. Do you see where there's a causal effect to where we have good intent, you know, has the namesake of a kid that was bullied. Good intent, but because we did not define and because no punishment is in here for people who don't follow it on the government side, not really a policy. Because there's no punishment for not doing this. It just isn't done. So as parents and advocates, this is where we have to do a better job of understanding this policy so that we can better represent our parents, because there are going to be principals out there that do not want parents to know that they have to put it on the form. Because if you put it on the form, it has to be reported. Okay, each school shall develop plans or programs including but not limited to peer mediation teams. I don't know of a school that has peer mediation teams. Anybody? No? Okay. All right. In an effort to encourage students to report and address incidents of bullying, violence, or threats of violence, at the beginning of each school year, each school shall programmatically address the issues of bullying and school violence with faculty and students. Now see, I want to cross this over with what I was just talking about teacher bullying. We also have to open the door and the perspective as educators to acknowledge students' perceptions that teachers are not being nice to them as well. We cannot limit the discussion because you know what it makes? It makes the institution look like hypocrites. Well, we only want to know about student. We don't want to hear your concerns about how, you know, Miss Dumbledore makes you feel. Okay? We have to open our minds up and our perspectives to accept that there is institutional bullying going on and also student bullying going on. We cannot limit it. It makes us hypocrites, and it also destroys trust. It also creates a toxic environment for our student population. Model policy. This is the state's model policy, all right? They even laid it out for any Board of Education that's too lazy to come up with their own. You can just follow this one. But it's a series of graduated consequences for any student who commits an act of intimidation, bullying, violence, or threat of violence. Punishment shall conform with applicable federal and state disability, anti-discrimination education laws, and school discipline policies. Gosh, that covers just about everything, doesn't it? Problem with that is, it's multifaceted. Yes, you may have an issue, but then you got to take into consideration, if you're an administrator, is the child that's being accused of bullying or being bullied protected? If they're protected, you've got to go through some additional steps. So one of the things that we have to cover is what happens when the special needs student is a perpetrator of bullying. You've seen that in your school, right? Special needs student says the bully. How about in Homewood? You seen that before? Where there's been accusations of your special needs students? Okay. So it's one of those things to where this is a reality, and you sit there and then there's a myth out there, with parents that don't have children with special needs. Oh, those special needs kids get away with anything. You just hire an attorney. There's never any consequences. Myth. Absolute myth. If you know what you're doing, if you know how to document it, it's not that hard to sit there and legally put yourself in a position to justify a change in the kid's LRE. It just isn't that hard. The problem is that when you're running through a manifestation determination, when you're running through an evaluation process, when you're running through a behavior plan and a functional behavior assessment, all of those components that would help deal with this particular issue, if you guys don't have your ducks in a row in those areas, then it's just not hard for James Galini to come in and say, come on guys, you didn't do this and you didn't do this. This kid has a recognized disability, and let's say the kid has autism and is only parroting the behavior that they see other peers doing. It's not necessarily intentional. It can be interpreted this way, and I understand it's being interpreted this way, but what supports do we have in place to help the child learn new skills so that they don't do that? Have you done that? No. Okay. Then let's try that first before we go to the extreme level of changing the kid's LRE. So I see a lot of knee-jerk emotional reactions from schools instead of a concerted effort to exhaust simple mechanisms before reaching that point of emotion. And I can tell you, manifestation determination meetings or hearings are some of the easiest things for me to go to, because the adults they have bloodlust, they're full of rage, they want consequences, they want their pound of flesh, and they're not making rational decisions in these meetings. And so it's not that hard for me to come in when you're supposed to answer two questions: whether the child's disability had a significant relation to whatever the action was. And the second one is, did you follow the IEP, which includes a behavior plan? I'm going to get you on one of those two things because they're ambiguous. But then if I get you all worked up because you're so intent on going after the kid, and I got you all discombobulated and emotional, and you just want consequences, and you want this kid to have consequences, and I'm sitting there going, can the kid even appreciate the consequence? So who's punishing who? Are you doing it because it makes you feel better as the adult? Because that's most of it. It makes the adult feel better. Doesn't serve the child. And so that's where there's that myth that's perpetuated out there that there's never any consequences. It's because we're not doing a good job with the existing process. And that's where the Supreme Court, when they have cases like that, tend to be unanimous. on special ed cases. Do you know why? Because they look at the rules and they go, come on guys, these are simple rules. Just follow the rules. Then you don't have to be liable for James Galini's attorney fees or this parent's corrective action if you just follow the rules. These things are in place for a reason. I will tell you that the situation, for example, in Parkland, Florida, that kid had an IEP. Now, Broward County is extremely protective and have been fighting tooth and nail not to have those records released publicly, to the point where they even went after the newspaper for releasing some of this information. Now, why is that? Because I've looked at some of this stuff, guys, that has come out, and they dropped the ball and they created that kid. That kid was created, and that kid was created by Broward County Schools. What ended up happening was a direct result of every possible safety net that this is intended to serve. Absolutely failed. And demographics came into this because, you know, Parkland is a well-to-do school. And this kid didn't fit into a norm. And so every time he would be trotted out of an alternative school back to Parkland, it did not take long for them to find a reason to kick him back out into the alternative school world within Broward County. Behavior units. I mean, you know, kid had mental health issues. He was not being served. And then when he got old enough, he revoked his own services. And then around the time, months leading up to this event, he asked for services back. It was a cry for help, and they told him no. So, my point in all of this is to say that these things, the anti-bullying, the behavior plan, the functional behavior assessment, the involvement of mental health, all of these things are there for a reason to help envelop our children with the necessary services in our ever-changing world. Quite frankly, these are things I can't do, but if we got rid of high-stakes testing, if we allowed for a lot more downtime, I mean, and that's what I think is insane about our public education system. There's labor laws in this country, except in public schools. We don't recognize that that's our kids' jobs. But everybody in this country is entitled to 30 minutes and an hour break, right? An hour lunch, right? Or you get in trouble, labor laws. Not in school. We have schools punitively punishing kids by taking away their whatever free time they do have available as a consequence, or not giving them breaks, period. And you sit there and you wonder why our anxiety is going up for our students, why it's a miserable place for them to go. We have created this environment. And instead of thinking what we can do to undo these environments, we just throw more money at the problem. And the same money that we're throwing, we're throwing the same money to the people who created the problem. And so we're caught in this cycle. And it's not like we don't know it. We know we have these problems. But it's just amazing to me that instead of just trashing No Child Left Behind, no, we just gave it a new name, threw some more money at it, and put a different focus. You know, special education's not in there, but we really did increase English as a second language funding there. Also with SLD over at RTI and all the combinations in there. You know, fine. But why didn't we remove all of those things that are unnatural and artificial obstacles to our children's mental health and their development? Because those are all still in there, thrown in with everything else, and we are not serving our children. But we'll figure this out in 20 years, but after we've absolutely screwed up 2 generations of kids. And I'm saying we because I am also a citizen of this country. I also have children. And through my tacit approval and just allowing it to happen, and you know, I'm a part of the cog in this grand machine. So I'm not pointing any blame that I'm also not pointing at myself. You know, I guess the only difference is that, you know, I'm also fighting for the education system in the form of advocating for my clients that are protected under these laws. And in doing so, I feel like I'm fighting for, you know, the system itself, because I do believe in it. We do not supplement my daughter's services. She gets all of her services through her public education IEP. And they've done a fantastic job. She was in St. Clair County first and Shelby County second. And I couldn't be more proud of both of those school systems and the staff that worked with my daughter. She made incredible gains. And so, you know, I believe in this law because I've seen it done, and I've seen it done right so many times. So they've got to have a procedure for reporting an act of intimidation, threat of suicide. Okay, procedure for prompt investigation, and that has to be substantive investigation. It has to be documented that you actually did look into it. And then I see too many schools over abusing FERPA as some excuse not to tell the parent the end result of whatever happened. And that, guys, it's a fiction. If you read FERPA closely, you'll find that a parent of a protected child or a parent of a child that's been on the receiving end of this, FERPA's destroyed for that one aspect. They have every right in the world to know what happens to that kid. But nobody reads FERPA. You know, they just use it as a fancy word to throw at parents to prevent access and to prevent information from flowing. And it's overused. Oh, you can't go into the hallway. You can't observe inside the special education classroom because of FERPA. Guys, that's not how FERPA is applied. FERPA is about records. If FERPA actually applied to how schools are trying to apply it, kids wouldn't be able to go on field trips. They wouldn't be able to be seen outside of the school. They couldn't be seen anywhere. It's a total misapplication of FERPA, an abuse in order to try to stifle parental input, parental observation, and parental involvement, and it needs to stop. Okay, so duties of the school: they must report the statistics to the local board of actual violence, submitted reports of threats of violence. But then at the bottom, the chapter shall not affect the freedom of speech and freedom of expression guaranteed to each student under the Constitution and the Constitution of Alabama, which of course doesn't give you any kind of freedom. So I don't know why they put the Alabama Constitution in there. Worst document in the world. And other applicable statutory law provided in the Code of Alabama. So the big thing that I want you to take away from this is use the form, use the form, use the form. And what I always recommend to parents is that they make 3 copies. They fill out all 3. They hand one to the principal, they send one to the superintendent, and then they keep one for themselves. They always hand deliver, or they send certified mail. Now, why do you want to also have one sent to the superintendent? Because the dog has a tendency to eat it. I tripped and then I accidentally hit the shredder, and it accidentally went into the shredder. I don't know where it went. I'm sure it's around here somewhere. I mean, these are the excuses, huh? Yeah. Oh yeah. It's in the mail. That's my favorite one. Which, of course, I sort of believe because it's the U.S. mail. That's why you send it certified. Now, this is where we're going to speed up big time. Guys, this is the evaluation process, reeval, all of those things, initial eligibility, evaluations for an IEP. The chart, I got this from Mastering the Maze, so this chart is in there. And the reason I want to put this up there is that, you know, it has this part where it says convene the IEP meeting in the red to determine when additional evaluative data, if any, is needed to determine continued eligibility status. Okay, now you see where I put red under additional data needed? You see that I put, did I put red on the other one, no additional data? I didn't do that. Because in the world of James Galini, and this is a parent attorney perspective, how in the heck are you getting present levels of performance and developing goals unless you have current and updated evaluation data? There are two reasons we evaluate. One is to determine continued eligibility, and the other one is where are you getting your present levels of performance from? If you want to develop good IEP goals, where is your evaluation data coming from? Where are your observation data, your assessment data? I can't tell you how many stupid cases I have to where I get the most recent evaluation from the parent and I'm looking at the IQ and the achievement measures and the observations, and it's all from 2014 and it's 2019. And you sit there and you go, well, you can do that. I know you can do it. You can do it from the standpoint that there's no disagreement on the IEP team that this child continues to meet the minimal requirements to continue to need an IEP. That's fine. But what does that have to do with present level of performance? What does that have to do with present level of functioning? Where are you getting that information from? And it puts you guys in an extremely litigious situation by conjuring things, by having it be the tingles on the back of your neck, or this is what I observed the child doing. Because if you say that I observed the child doing that, which is where I frequently see a lot of this crud, and then I have a parent saying, my kid can't do that, then you see now all of a sudden I got a she said. And then you got a due process case to sit there and work through it. And what is the number one thing I'm going to ask for at the onset of every due process case? What's at the top of our request list, Dan? Always.
For every due process, more testing, more evaluations.
Updated evaluation. So if you know that I'm after updated evaluations, why am I wanting updated evaluations? Because I'm wanting to validate and verify the present levels of performance for the goals that you guys have created. And then I want to compare those over to the services. And what are the services that you've created? You know, because that goes over to the measurable goals. So they're all connected. So I understand what the state's doing here. This is just a guide. I understand saying, because we did that with our daughter. There was no question that my daughter has autism and will continue to need services till she's 21. No question. At the same time, that didn't mean that we did not give consent to update evaluations in pertinent and relevant areas that would go into development of goals in order to identify present levels of functioning. So because I was a good advocate for my child, I also was helping my district insulate themselves from a lawsuit from me. And every good advocate parent and every good advocate should be working to try to insulate the IEP team from any kind of legal challenge. Now, why would you do that? Because that's how the process works. You want the child to receive a FAPE. So of course I would be advocating on your behalf. Because if you were doing exactly what the IEP dictates, then what would I be complaining about in the first place? So of course I'm always trying to help my clients achieve a good IEP, and by doing so, I am also creating an IEP that insulates the school system from future due process complaints, not necessarily from me. I mean, I've had situations to where, you know, I felt like I've exhausted myself in trying to help make the parent a better advocate, and it just didn't take. And it's a rare situation, but sometimes parents are the problem. And in that kind of situation, I feel for the school, because at that point, I feel like I do a pretty good job of trying to see it from both angles. I never go into a case thinking that this was 100% the school's problem. And I'd never, and very rarely is it some kind of an intentional issue. You do have your occasional bad apples, but most of this stuff is just a confluence of mistakes and errors and ignorance. Those are all curable. You can fix those. It's not intentional. It's not evil. That's the majority of my cases. It's just a lack of perspective and training will solve a lot of these problems. But sometimes parents will not let go of the emotion, the raw anger, the hurt, whatever the motivation is. And it really is a toxic factor on the team. And in those situations, hey, I am not your attorney if you are after revenge. Okay, no matter what the stereotype is about Italians, that's not what I do. I believe in this process. Like I said, we need buy-in from the education system in order for any of this stuff to work. So why? What benefit would it have for me to come in there trying to lay waste to everything? At the end of the day, I get to go home to my own family, and I get to be a member of my own IEP team. And I want to make sure that I'm leaving my client in a better position than what I found them. And part of that has to do with educating them to be better and more positive and conducive communicators on their IEP team, and understanding what to focus on and what to let go of. So I always recommend that, yes, you may not want additional data for continued eligibility, but always take that into consideration that maybe you don't need expansive evaluations in order to get present levels of functioning, but you can sit there and isolate what you do need in order to make sure that you're covering your bases. This is the meeting notice. Purpose of the meeting, guys, it's in the law. All of this stuff is in the law, all of it. That's what goes into creating these meeting notices. What I don't like is the ambiguity on the left-hand side. Doesn't necessarily tell the parents what the meeting is about. And I have a case currently to where they were verbally telling the parent that the meeting was for this reason and the meeting was for that reason, when in reality the meeting was about a change in placement. But they shrouded the purpose of the meeting in order to get the parent to the meeting, in order to hoodwink the parent and change the kid's placement. Because once the parent steps over the threshold of the door, the IEP meeting's started. So if the parent turns around and goes, oh, now I know what it's about, and they leave, well, that means the parent was there and they participated, and you can just notate that the parent left the meeting early. And then you can go ahead and do whatever you're going to do. And that's a current due process case right now. Because a meeting notice was to develop the annual or revise the current IEP. Very ambiguous. So if the parent sends you an email and asks, what are we discussing at the meeting? Transparency and smartness would dictate that you respond back, we would like to discuss boom, 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 and boom. Don't be deceptive. That creates problems. I highlighted the red because your input is important to us. We encourage you to make every effort to attend this meeting. If you would like to participate by phone, please call the person below to make arrangements. You may bring other people whom you feel will be helpful to you in this process. That's a protected activity, guys. You can't sit there and tell them they can't bring their advocate or they can't bring Grandpa Joe. You can't do that. It's a protected activity. I can't tell you how many cases I'm starting to see or reports I'm starting to see where they're trying to freeze advocates out of these meetings. I mean, they don't try to freeze out parent attorneys, but they're trying to freeze out advocates. They can't do that. Protected activity. So you are fully protected under the rights addressed in your copy of the special education rights, which, I'm not happy with how, they're using the minimal standards of what those rights are, but it encompasses everything that we discussed this morning, including the Title VI and everything. It's just not included in all those rights. Just keep that in mind. Now, this is a huge one down here. Documented attempts to contact parent. Guys, this is one of the biggest misunderstood area that I deal with when it comes to having IEP meetings without the parent there. This is the actual code, okay? This is the actual law, because the State Department of Education obviously either isn't reading it or isn't interpreting it correctly. And I can tell you that the federal court may be split in some of these analysis, but I'm telling you my perspective. Parental involvement in the IEP meeting. Written notification early enough to ensure that they will have an opportunity to attend, and scheduling the meeting at a mutually agreeable upon time and place. You may invite, but you propose a date. You don't dictate a date. And just because you put an initial date in there doesn't necessarily result in your first attempt to schedule. Many schools do. You just pulled a date out of nowhere. How is that your first attempt to do anything? You're inviting the parent. Let's say the parent puts in a written request for an IEP meeting. You have 30 days to comply. You still send a notice out with a date you pulled out of nowhere. How is that your first attempt? Try to find a time that's mutually agreeable to schedule. Okay, so you sit there and you go, well, you got first attempt and second attempt. And then after the second documented attempt, we can have an IEP meeting without the parent, right, James? At your own risk. Because, see, down here, in the part that the State Department either doesn't understand or doesn't want you to know, a meeting may be conducted without a parent in attendance if the public agency is, what does that say? Read it out loud.
Unable to convince.
Unable to convince. Now, what does that mean, unable to convince? Does that mean that the parent is a single mom working at Walmart and only has Tuesday afternoon open and the rest of the time she works? And you guys try to have the meeting at every Thursday at 11 because it just so happens to correspond with when everybody's available? No, that is not unable to convince. That's just mom having a conflict because she's the single income earner in her family, and you guys aren't taking it into consideration because you've got families and you want to be paid during your meeting. But yet the single mom working at Walmart, if she doesn't go to the meeting, she doesn't make rent. Or she doesn't go to work, she doesn't make rent. Nobody thinks about that. So you have the top part that says that you need to schedule at a mutually agreeable time and place so that she has an opportunity to participate. And we already know what the procedural rights are. I mean, those are serious procedural rights for parental participation. Then down here, yeah, you can have a meeting after 2 reasonable efforts or attempts to convince the parent to attend. But convincing the parent to attend denotes that there's some kind of disagreement or resistance on the part of the parent to attend, right? Why would you need to convince somebody who wants to go? You wouldn't need to. So the only documented attempt in order to safeguard yourself from a potential due process complaint where you have substantively harmed the child, and not only that, is trampled on the parental rights by having a meeting without them present. And if you changed anything substantive in that IEP, then your procedural error now tipped over into substantive because the parent did not participate. So why, and I have a stupid case now, and it irritates me because so many times over the summer, it was deceptive in setting this whole thing up and wanting to railroad this kid over to the special school. Oh, well, we just want to have an IEP meeting to discuss home things. What does the home have to do with the kid's program? You already developed the IEP for 1920. So that was deception one. Can you reschedule? We have a psychological appointment in July. And I'd like to have that the psychological report back for the benefit of the IEP team to refer to. So can we meet after we get the report back, maybe a couple weeks into school? Silence, no response. First documented attempt. Second documented attempt was, hey, can we go ahead and meet and discuss whatever? And then they just went ahead and had the meeting. Even though the parent wasn't resistant, the parent even sent a couple emails to administration asking what the purpose of the meeting was. Because over here it was about the home life, and over here it was about something else. But the parent had asked both the times, isn't it more prudent to just wait until we get the psychological report back and see what's going on at the beginning of school in order for the IEP team to make a good decision? Well, you would think that is prudent. But what ended up happening? Nope, they had the meeting without the parent, claiming that they had sent 2 notices out and therefore they were justified in doing it. No. Parent was not resistant and they were deceptive on purpose. 2 violations. And because it ended up resulting in a change of placement, it's a dang good due process case. Because now it created a substantive change. All preventable. Stupid preventable. That's the part that the State Department's not telling anybody about. Unable to convince. So I would train all your people, please look at that. Please understand that your documented attempts, you need to show where they resisted you. And believe me, it happens. I have clients that they're not answering the door, they're ducking calls because they know an LRE discussion's about to happen, or there's going to be a change in a third-party contractor that's working. Believe me, I know that those things happen. And in those situations, that's how you protect yourself, is that you document, not that you sent the notice home, but you tried to convince the parent to participate. And how did you try to participate? And so many times I say, tried to call the parent. Come on. What documented proof is that? Because I had a school system do that once, and then I just asked the parent to send me a copy of their cell phone call list, and I saw no missed calls from that school. It was a lie. That isn't hard to track now, guys. This stuff is not hard to document. Just do a better job of documenting and you're okay. This does happen. But don't have meetings without a parent because she's a single mother and you're putting her in economic damage by dictating when you're meeting. Because you know how irritating it is for us parents when I'm sitting in a meeting at 2 o'clock and I'm having teachers tell me I need to be done by 3 because I've got to go get my kids. As though the rest of us don't have kids. But the rest of us aren't getting paid. You are. And what it is it sends a message to the parent. And let me tell you, these are all things that are discussed not in front of you guys. But it's absolutely hypocritical and it's insensitive.